Hi, welcome to the Teach Out on Free Speech on University Campuses. I'm here today with Professor Leonard Niehoff, who is professor from practice at the University of Michigan Law School, as well as a practicing attorney at the legal firm Honigman, Miller, Schwartz & Cohn. Professor Niehoff, could you first tell me a little bit about how you first came to free speech issues?
Sure, thank you for inviting me to be here. So when I was in law school and not positive about the direction I wanted my career to take, I had the opportunity to study with a wonderful First Amendment scholar by the name of Fred Schauer. And at that point, I realized that this was an issue that was deeply complex, incredibly interesting, and that I wanted to not just continue to think about, but where I actually wanted to practice in the field. And so I was fortunate enough to find a position at a law firm that allowed me to do that, and I've been fortunate enough to have the opportunity to teach it here at the University of Michigan Law School.
Terrific. And I think as will become clear, your views tend to be very supportive of the First Amendment and the way that it's been interpreted in the United States in the 20th century. But I first wanted to let our viewers know that in many cases you are very much in support of issues and ideas that were often associated with the political left. So for example, you mentioned on your blog that you've had something like trigger warnings in your classes for some time, and that you very much support diversity on campus as well as in society. And then most interestingly, I think you were a very staunch supporter of the right of the law school to include issues of race as part of their student admissions in a case that went all the way to Supreme Court. Is that a reasonable characterization of your views?
I'm certainly a very strong supporter of diversity in higher education and in recognizing the importance of diverse voices in many, many contexts. So that's certainly the case. And a lot of my thinking and work has been around the idea of trying to reconcile First Amendment doctrine with these concerns that I see as very legitimate concerns about diversity and about minority populations and the effects that speech can have. I would say that I started giving what you referred to as trigger warnings long before I think the phrase trigger warnings existed. When we talk about First Amendment, we talk about lots of difficult subjects. We talk about speech that is racist, speech that is misogynistic. We talk about obscenity. We talk about child pornography. There are lots of issues that are incredibly sensitive, and it's always just seemed to me good pedagogy to let the students know that we're going to be talking about these hard things, and that I'll do my best to make sure that the conversations are respectful and inclusive.
So let's get on to some of the questions I have for you. For much of the 20th century, American interpretation of the First Amendment was very much about allowing everybody a voice. And during that time, during the 20th century, we saw a lot of progress on issues that, again, are associated with progressive causes. There was women's suffrage, the Civil Rights Act, gay marriage, and so on. It would seem at the very least that that interpretation of the First Amendment certainly didn't hinder that change in society. Do you think that it might actually have contributed to those things?
Oh, I think there's absolutely no question that freedom of expression has played a critical role, in the advancement of equal protection, equal rights, and civil rights. And I think one of the pieces of evidence in support of that is the very strong efforts that were made, I'll take the 60s as an example, to silence people. Because the opponents of civil rights and the opponents of equal protection recognize the power of speech. So, for example, you think of the very graphic images of Alabama Commissioner Bull Connor ordering that fire hoses be turned on protesters, that attack dogs be loosed on protesters. The civil rights movement engaged in all kinds of different forms of speech and continues to do so. Publications, pamphlets, leaflets, signs. You might think of our own communication on campus around the hashtag BBUM movement as being a part of that tradition. And then also speech that was conveyed symbolically. through marches, through sit-ins at lunch counters, through refusing to take the seat at the back of the bus, through the wearing of black armbands. And again, we see continuations of this, kneeling in protest to police conduct, or students who have, or demonstrators who've put a piece of black tape across their mouths, sort of the ultimate symbol of being rendered speechless and communicating a message in the very act of doing it. So we have all these very powerful images, and there's no question that there was a counter movement during the civil rights movement to try to suppress all of that. And it wasn't just techniques as brutal and obvious as turning fire hoses and attack dog loose on protesters. There were other perhaps subtler strategies as well. For example, there was a Southern strategy to bring lawsuits against the Northern media, because the Northern media and the Eastern media particularly were doing a lot of reporting on the civil rights movement. And those lawsuits reflected a campaign to try to dissuade the Northern media from reporting on the civil rights movement. And the hope was that enough judgments against those newspapers would keep them from reporting and might even put some of them out of business. And so the decision from the United States Supreme Court in New York Times versus Sullivan, which is often seen as one of the signal moments in the history of the First Amendment, is also a signal moment in the history of equal protection. That case, although it presents as a First Amendment case, is very much a civil rights case and very much about the advancement of civil rights.
And in what you said, what I heard was that in many ways the First Amendment was protecting minority voices.
Absolutely. And in fact, the First Amendment is a non-majoritarian principle. It's often said the majority doesn't need the First Amendment because the opinions of the majority will not be prohibited, suppressed, persecuted. It really is a it is a principle that by its very design seeks to protect those voices that are the voices of minorities, of the marginalized, of those who are not empowered.
I'm sure that, in many of your classes, you sometimes have students who challenge the First Amendment. What do you?
I hope so.
What do you present to them as the strongest case in favor of free speech?
Well, so there are a number of different models that we talk about in this context for why we believe in free speech and why we think a free speech principle is important to a participatory democracy. One of those models is the so-called marketplace of ideas model, where all ideas are welcomed in, they compete with each other, and when it goes well, the better ideas and the more truthful ideas emerge. It is an optimistic model, and the justice who first articulated it in a Supreme Court opinion, Oliver Wendell Holmes, was a realist. He understood that there would be times where it would not work, where it would go wrong. And right now, the marketplace of ideas model is particularly challenged because of the number of informational outputs, our ability to process them, so forth and so on. And in the opinion where he describes this, Holmes says, I think rather poignantly, it's an experiment, as all life is an experiment. But we have placed tremendous faith in it. So we talk about that model. We talk about some other models. There are many that can be used to defend an expansive principle of freedom of expression, but that's certainly one of the principal ones.
You mentioned participatory democracy, and there are democracies today in the world, like Canada and Germany, that have very specific kind of anti-hate speech laws on the books that would probably not pass muster, at least under current interpretations of U.S. law. That suggests that democracies won't crumble without free speech the way Americans have interpreted it. But what's your opinion of that?
Well, when you look, I think, at some of the European laws and the constitutional provisions and so forth that try to get at this, you said that they wouldn't pass muster under current interpretations of the First Amendment, and I think that's overwhelmingly true. And there are some reasons that that's the case, and I think it's important to understand why what is upheld there would not be upheld here, because they're legitimate objections. When you look at many of those laws, one of the things that you notice is that they are vague. It's hard to tell what qualifies as prohibited speech. Sometimes we hear people talk about hate speech here. That's not actually a category of unprotected speech that the Supreme Court has recognized. So the minute you start talking about hate speech, you're already using a term where it's very hard for people to tell what's inside of it and what's outside of it. Many of these European or many of these laws in other countries have what I would identify as significant vagueness problems. And that's worrisome because obviously if we're going to punish speech, we don't want people to have questions about whether their speech will fall inside a prohibition or outside of it, because people then may decide against speaking at all. Some of those provisions also have what I would view as overbreadth problems. That is, there is some category or subcategory of speech about which we would have legitimate concerns, but the breadth of the regulation manages to capture also other speech that might be offensive, but that we would overwhelmingly agree is valuable and contributes to the marketplace of ideas. There are enforcement problems. You have to remember that even when you have a law, it still has to be enforced. And if it ends up being enforced symmetrically, then the speech that gets silenced that you don't like may be fine with you. Holmes even said, you know, the persecution of opinions you dislike is a perfectly natural thing to understand. But it will also end up suppressing some of your own speech and the speech that you disagree with. Given the way in which political power is allocated, once we get to the enforcement stage, the concern is that the law will be enforced in ways that actually end up disadvantaging minority and more marginalized voices. And you lose something when you have statutes like this. You lose a number of things. One thing you lose is what's sometimes called the safety valve. That is, we believe that when people speak, they're very often just blowing off steam, and that helps preserve social order. There's a gap between speech and conduct, and that allowing people to express their views, even views we find odious, nevertheless has some positive safety valve effect. When you start prohibiting speech, you lose sort of the moral standing that you have around the idea of tolerance. You have, by definition, become less tolerant of certain points of views, and you've ceded some moral territory, I think. And finally, you've lost sort of the moral claim to courage. There's a wonderful passage from one of Justice Brandeis's opinions, and with your indulgence, I'd like to read it just because I think it's so powerful. And bear in mind, as you're hearing this, that Justice Brandeis was no stranger himself to persecution. He had been on the receiving end of vicious anti-Semitism for much of his life. He had a colleague on the United States Supreme Court who would not even shake his hand because of his virulent anti-Semitism. So the voice you're about to hear is not the voice of someone who is a stranger to prejudice, to bias, and to the ways in which words and gestures can wound you. But Justice Brandeis said, quote, "Those who won our independence believed liberty to be the secret of happiness and courage to be the secret of liberty. They believed that it is hazardous to discourage thought, hope, and imagination, that fear breeds repression, that repression breeds hate, that hate menaces stable government, and that the fitting remedy for evil counsels is good ones," unquote. And that is indeed one of our central First Amendment principles, that the best remedy for the speech we dislike is more speech.
Thank you. Now, you know, speaking more about the kind of speech that some people might want to curtail, increasingly there's research that shows that some forms of speech lead to mental stress, and which itself can turn to physical harm, especially over prolonged periods. That suggests that maybe, you know, some forms of stress are in fact violence, which I think most people in the United States would say is not something that we want to allow, at least on a casual basis. What's the argument in favor of free speech against that kind of claim?
Well, I'd like to answer that by highlighting something that I think is terribly important. I may even come back to it again later. And that is that this research is on to something that I think it's terribly important for us to notice. And I sometimes call this the critical pause. And that is, before we run off to our First Amendment arguments, which I believe in and I'm a great supporter of, it is essential that we take a moment to recognize the ways in which words really can wound people, hurt them, interfere with their learning process or their ability to do their job. Words are powerful, words matter, and I don't think there's any question that they can have psychological effects. And I think that one of the mistakes we get into sometimes is we don't take the critical pause. We don't take the time to honor and recognize that some kinds of speech costs us something and costs some populations more than it costs others. I think that's a terribly important step in our analysis. But I would go on and I would say what that research tells us is that words are powerful. That's why we protect them. It's true that there are consequences to them, but it's also true that that is why we protect them. And there are lots of words that cause stress that we view as productive stress, that we view as part of growing and learning and becoming more fully human. In law school, we have a convention of calling on students, cold calling on students when they don't expect it. At some very low level, I'm sure that's stress-inducing for students. What you're describing is a much higher level of stress, a much higher level of psychological impact. But things that move us at that much higher level fall into lots of different categories, including things that we sometimes want to protect. I don't think the science gives us a principled basis on which we could distinguish those things that result in stress that we view as solely destructive from those things that we view as stress that has some productive component to it.
And do you, can you imagine a situation in which maybe research would, move this boundary a little bit, where you can say, okay, there are categories of speech that are currently protected that really do seem to be, largely harmful with very little other merit?
I'm generally skeptical of basing jurisprudence on the current state of science at the time. There are certain fields where I think that's the tack the Supreme Court has taken, and it's turned out to be deeply problematic. And I think the problem is not one that science can answer, because I think that there will always be reasonable disagreement, because reasonable people can disagree about this, about what kinds of things, where that line is, that you have something that has become so stressful that it is no longer the type of speech that we should protect. Great.
So I want to turn a little bit to our current societal atmosphere in which these kinds of conversations are taking place. You wrote an article about the University of Michigan's own anti-hate speech policy from the 1980s. That policy was struck down by the courts. And in your article, you say something really interesting, which is that both sides of that particular issue seem to be very honorable. We're really trying to do the right thing and seem to be trying to resolve these issues in a civil, kind of rational way. In the paper, you suggest that today this is a much more difficult question. Why do you say that?
Well, the case that you're referring to is Doe versus University of Michigan, was a federal district court decision. And I would encourage people to go back and read it. It's one of the seminal decisions in the area of student speech codes, and lots of law students read it. But I think there's something to be gained by everyone going back and reading it. Because one of the things that's striking is both sides, when you read the opinion, seem to have a point. The University of Michigan, I'm fully persuaded, was acting in good faith. It was trying to address some things that had happened on campus that were worrisome, deeply distressing to a number of students, and seemed to call for some sort of serious and material response. On the other hand, the policy that was adopted turned out to be something of a blunt instrument. And all the objections that I mentioned to you earlier, vagueness, overbreadth, how it's going to be enforced, all of those problems were present in the policy. And so it was sort of unremarkable that the policy was struck down. And in that sense, the case doesn't seem legally terribly important. But I think socially it's really important, and there's a pedagogical sort of point to it, which is when you look at the opinion, you can see people trying to figure out how to mediate different points of view and treating each other sort of respectfully in the process of doing that. It feels to me like that was a great stage setter for a lot of progress that we haven't had. That in fact what's happened is we have increasingly been caught in a crossfire of labels. There are labels like snowflake or like hate speech or that they get bandied about that aren't arguments, they're conclusions. And it feels increasingly to me like people run off into their separate foxholes and don't try to have a material exchange of ideas to understand what's at stake for everyone who's involved in the dialogue. I think we're giving ourselves too much of a break. That we need to have harder, deeper conversations, trying to understand the other side's point of view. Maybe I believe that because I believe in the power of speech and the power of the First Amendment.
Wonderful, thank you. Is there anything else that you would like people to know about free speech issues? For example, certain myths that keep reappearing.
Well, I think there are a couple things that have come up a lot in recent conversations that around campus and nationally even that I think warrant some clarification. One is that I think people are often confused by the difference between incitement, which is where a speaker is encouraging an audience to do what they want and basically telling them to engage in an act of violence and lawlessness immediately. Incitement can be prohibited, can be punished. That's different from a situation where the audience is reacting in a hostile way to what the speaker is saying. And that's an important distinction to make, because the problem is that if we allow that second situation, if we say, well, we're going to shut the speaker down the minute the audience doesn't like what the speaker is saying, then we give the audience what is sometimes called the heckler's veto. That is, those who disapprove of the speech can shut down the right to speak altogether. That's a non-starter for First Amendment purposes and would essentially eviscerate the whole idea of freedom of expression. So I think it's important to understand that distinction because I see it muddied fairly frequently. I mentioned this earlier, but I think a lot of people believe that there is a category called hate speech and that we've recognized it and that we know what's in it and that it therefore has legal meaning. It really doesn't. And so very often when people refer to hate speech, it's important to get some clarification about what they mean. They might mean speech that can be prohibited. There are forms of discriminatory speech that in specific contexts that absolutely can be prohibited. They might mean something that rises to the level of a true threat. So it's important to understand what people mean by it to make sure the discipline is there to think about what fills that vessel. But also because some things may belong in it, some things may not, and some things may be falling categories that can be prohibited, some may not. The last, I guess, is sort of a pet peeve of mine. Very often these conversations are terminated when someone says something like, well, there's a right to free speech, but you can't cry fire in a crowded theater. There are whole articles that have been written about why this example is not helpful to free speech discussions. It's an example that was used by Justice Holmes in a very early opinion. It caught on, it gets trotted out routinely, but it's actually not very useful. And it's not useful for this reason. If the point of the example is simply that there are forms of speech that can be prohibited, we all know that's true. Blackmail happens through speech, extortion happens through speech. There are lots of forms of speech that we can prohibit. If I walk into a bank and I hold out a bag and I say to the teller, I've got a gun, fill this with $100 bills, I can't defend when I'm charged criminally by saying I was just talking. So we all understand, of course, that there are forms of speech that can be prohibited. That's not a conversation ender. That's maybe at best a conversation starter, but it doesn't foreclose real questions, doesn't answer the real questions that remain. And it's important that people keep talking beyond that to try to figure out what kinds of speech we think we should be prohibiting, if any, and why we should be doing so, how we're going to define them so they're sufficiently specific, how we're going to avoid the problem of overbreadth, and how we're going to avoid the problems that result when the law comes to be enforced.
Thank you so much. I know you teach First Amendment classes. How do you usually end them?
Well, I often end them by doing a brief recitation of all the questions that have been left open. And this is, of course, frustrating to law students because, like all students, they would like to have a clearer sense of all the things that have actually been answered. But I think it's important to recognize that we shouldn't think of the First Amendment as being this untouchable thing that exists and that we have to figure out how to navigate. It is, in a very real way, organic. I often tell my students every single word in the First Amendment has been interpreted to mean something other than what it says. When the First Amendment says Congress shall make no law abridging the freedom of speech, Congress has been interpreted to mean something other than Congress. No law has been interpreted to mean something other than no law, so forth and so on. So I think it's important that everyone understand that this is an ongoing project. This isn't a matter of looking, not just a matter of looking for answers. That's certainly a legitimate undertaking. But the bigger undertaking is for us to be engaged as, again, members of a participatory democracy, trying to reason out what this sort of Delphic provision in the Bill of Rights means, what it should mean for us today, and how we're going to shape it today so that we can live with it in the future.
Wonderful. Thank you so much. And thank you so much for being part of this teach out.
My pleasure to be here. Thank you.